as I told you yesterday, the Supreme Court was making some big decisions today, and were they? Welcome. It is Erick Erickson here. It's my show. I'm happy to have you call in 877-97-ERIC, 877-973-7425. It is a big day because of the United States Supreme Court. The sound you hear or heard a couple of hours ago was Merrick Garland flushing down the drain his lawsuit against the state of Georgia, thanks to the United States Supreme Court. It was a very big case about Section 2 of the Voting Rights Act, which the Supreme Court all but gutted today. Well, they didn't gut it, but they did. They don't want to come up with a new rule. They don't want to come up with a new test right now, which is going to make it very, very difficult for Congress to write a voting rule that satisfies the Supreme Court, since the Supreme Court refused to come up with a test. It was actually a very fascinating ruling. Most people guessed that Sam Alito was going to be the author of the case, in large part because he wound up not getting the majority in the Catholic Charities case, the Fulton case. Now, the Fulton case, that's where Chief Justice John Roberts wrote the majority opinion that said essentially in a 9-0 decision that the city of Philadelphia can't discriminate against Catholic Charities. Catholic Charities wanted to provide adoptions, but Catholic Charities only provides adoptions to heterosexual married couples. They don't do gay adoptions or adoptions to single people or foster care in that regard. And the Supreme Court, in a 9-0 decision, said they had to allow Catholic Charities to do it. Interestingly enough, Don Lemon from CNN, if you want an idea of how far out the mainstream he is, Don Lemon from CNN has gone on a tirade about that 9-0 decision, saying that no religious group should be able to provide adoptions in this country. That's a CNN news anchor. Gives you a perspective of how far outside the mainstream he is. Nonetheless, so I'm setting the stage here going back to that decision because it's important you understand the dynamics. Most every legal scholar assumes Sam Alito would be writing that decision. And in fact, Sam Alito's concurrence, it wasn't really a dissent, it was a concurrence. Sam Alito's concurrence reads like it was supposed to be the majority decision. It was a very lengthy dissent, which indicates it should have been the majority, and some of the language used suggests it had been the majority and didn't get fully revised. Now, this is important because every month the Supreme Court hears cases from October until sometime around the beginning of June when they wind stuff down and start issuing all their final decisions. And every month there's a rotation. Whoever is the ranking justice in the majority, it's either the Chief Justice or the ranking justice, assigns the opinion. And the rule is that each justice gets an opinion that month. So you can kind of say, okay, this case was argued in October. They assigned the opinions in October. This justice had a majority opinion. This justice did, this justice did, this justice did, this justice did. Okay, so this must be the guy who wrote the opinion. Well, it was pretty obvious by the delay in the Catholic Charities case and the Brnovich case in Arizona that there was some jockeying behind the scenes. So when Chief Justice Roberts came out and wrote the Fulton case, Democrats and progressives' brains blew up. I mean, you could nearly hear the explosion because that pretty much guaranteed Sam Alito was going to write the Brnovich decision, the voting rights case in Arizona. Not only that, Sam Alito has a reputation on the court for basically saying, screw the precedent, this was badly decided, and swings the pendulum dramatically in the other direction. That's one of the reasons there's really informed, really good educated speculation that the reason Alito had the Fulton case, the Catholic Charities case, taken away from him is because he would have been very, very expansive, throwing out previous Supreme Court cases and carving out a very expansive religious liberty protection that even Brett Kavanaugh and Amy Coney Barrett were like, I think we may be going too far too quick. They weren't opposed. They just didn't think they needed to do it immediately. So that gets to the Brnovich case. Alito has a reputation of being a wrecking ball to pass Supreme Court precedent, being very, very conservative. And that's exactly what we got today. Essentially, it eradicates any grounds the Department of Justice has against Georgia in the lawsuit that Merrick Garland promised. In fact, it guts Stacey Abrams' argument she's making in court against Georgia and also Texas and Florida in those voting rights cases. Let me explain the case in Arizona. and how much broader Sam Alito's opinion goes. The case in Arizona involved two issues. One was ballot harvesting. Ballot harvesting is something the left loves. Essentially, if you're in a state that mails out absentee ballots, for example, I'm in Georgia. Let me explain how Georgia does it, because about 40 states do what Georgia does. In Georgia, when you send out an absentee ballot, it goes in a list at your local board of elections. And you can go to the local board of elections and you can see who requested an absentee ballot, and you have the right to challenge that absentee ballot. For all of the people who claim that the Democrats stole the election in Georgia, just consider the Republican Party in Georgia never engaged in the very basics of challenging the absentee ballots. They never did. They came up with all sorts of excuses saying they weren't allowed, there was this, or no, you're allowed, and they didn't even try to fight it. They just didn't do it. Another reason why so much of the arguments you hear about the stolen election in Georgia are really it's butt covering by Republicans who failed to do the basics to ensure ballot integrity. They could have challenged absentee ballots, but they didn't. All the absentee balloteers, they're on a list. You can go get the list. If you're in the county, if you're a county resident, you can go to your county board of elections and say, hey, I live in this county. I want to see who got absentee ballots because I want to challenge some of them. Well, what the left does is they get Democratic activists to go get the list of absentee ballots. And then they show up at people's door, knock on the door and say, hey, I know you requested an absentee ballot, and I know from the Board of Elections that it has arrived. If you haven't cast your ballot yet, I would like to encourage you to cast it, and I will very helpfully take it from you and send it back to the Board of Elections for you. That's ballot harvesting. Progressive or conservative activists, but typically it's progressives who do it. Very few conservative groups engage in this. Progressive activists show up at your door and say, I know you got it. Let me have it. In fact, in Georgia, in the primaries, Brad Raffensperger, the Secretary of State, because of COVID, sent out absentee ballot forms to everyone. Anyone who wanted an absentee ballot could get an absentee ballot for any reason whatsoever. And a lot of progressive activists from Stacey Abrams groups and others went out into particularly Democratic areas of the state and said, hey, let's get this ballot processed for you, and we'll collect it and we'll carry it back. Pay no attention to the laws in Georgia that say you shouldn't do stuff like that. They were doing it anyway. Well, in Arizona, Democratic groups were specifically engaged in this. They would get lists of who had absentee ballots. They would show up at their doorstep and say, hey, you can trust me. I'll get it back to the Board of Elections for you. Now, what could happen from a malicious person is they say they'll take it back and then they burn it. They know you're a Republican, so they destroy your ballot. So Arizona passed a law and said you can't do that. You're not allowed to harvest ballots. No one is allowed to come to your house and ask you for your absentee ballot or encourage you to fill out your absentee ballot. That was the one issue. The second issue in Arizona was voting in your precinct. A lot of states, including Georgia, under its new legislation, say that you've got to cast your vote in your precinct, and if you don't cast your vote in your precinct, it's thrown out. Your ballot is disregarded. It's not counted. And what Democrats argued in Arizona is, okay, that's fine. You're voting in a precinct and exclude all of the people, all the candidates who are only in that precinct or only in precincts cast, not the one where he showed up. But in Arizona, there are people who are statewide candidates. Every precinct is entitled to vote in those statewide races. You should require that even if you're going to throw out someone's ballot because they voted in the wrong precinct, if they are a registered voter, you should still count the candidates who are statewide. And Arizona argued that no, a voter is responsible for showing up at the right precinct. And if they do not show up at the right precinct, because the elections officials have to conduct an election, elections are never flawless. There are already problems. This introduces new variables to create problems. So we should reject the entire ballot. Arizona did not dispute that a lawful voter could go from precinct A to precinct B, cast their ballot in precinct B, and yes, they're a lawful voter, but they went to the wrong precinct. We shouldn't count anything. The Democrats argued if someone who's supposed to vote in precinct A goes to precinct B, the statewide candidates, they're still good votes. Count them. The Supreme Court today sided with Arizona and said if a voter shows up at the wrong precinct and casts a ballot in that precinct, the ballot can be rejected, upheld Arizona law. This is very important because those two components are in Georgia's new law, but The Supreme Court was more expansive than just that. What the Supreme Court said is that today they were not going to articulate a hard and fast rule against or around or embracing or changing Section 2 of the Voting Rights Act. Section 2 of the Voting Rights Act says anything that makes it more difficult for a class of voter to vote tends to be unconstitutional. If every voter's vote is made more difficult, it's not unconstitutional. If you're singling out black voters, for example, it is. And what Sam Alito said is that when the Voting Rights Act was changed in 1982, the presumption of the law, and it's clear from the language of the law, is that every voter will vote on election day except a small pool of voters who have a legitimate excuse for absentee balloting. In the 21st century in the United States, that's no longer the case. The bulk of voters vote early. They vote by absentee ballot, no excuse absentee ballot. They show up early in locations to vote. So the parameters by which Section 2 of the Voting Rights Act governed no longer exist in this country. Therefore, we can't really look at these situations and say, hey, this runs afoul of a law that contemplates a pattern of voting that no longer exists in this country. It was a pretty expansive decision by the Supreme Court. The plaintiffs were unable to provide, this is Alito writing, the plaintiffs were unable to provide statistical evidence showing that ballot harvesting restrictions had a disparate impact on minority voters. The modest evidence of racial desperate burdens caused by the law in light of the state's justifications lead us to the conclusion that the law does not violate the Voting Rights Act. This scuttles Merrick Garland's case against Georgia. Now, because the Supreme Court did not write a hard and fast rule, Merrick Garland can technically proceed with his case, but even so doing, it makes it much, much harder for Merrick Garland and the Department of Justice to sue Georgia. Why? Because their case is premised on Section 2 of the Voting Rights Act. And the Supreme Court today made it very clear that if every voter is inconvenienced, it is de facto presumed legal. The allegation from the Democrats about Georgia's new voting law is that it will overwhelmingly harm black residents. What the Supreme Court says today in this Branovich case in Arizona is that although something may have disparate impact on minorities, if it's not designed to target minorities, if every single person in a county has the same issue, it's presumed to be legal. And Georgia's law, though the Democrats say it was designed to target minorities, it's not really true. It impacts every voter in every county equally. Every voter in Georgia will have to comply with the same standard. Based on today's ruling in the Supreme Court, that means Georgia's law is constitutional. Georgia is allowed to make it more difficult to vote, particularly as the Supreme Court notes today, more and more people are not showing up on election day to vote. They're voting by other means earlier with no excuse. That means states have an extra burden to regulate to make sure there's no fraud. And Sam Alito said something else. The state does not have to show fraud existed in order to show it's taking steps to prevent fraud from happening. So the state does not have to provide evidence of fraud to impose restrictions that are to protect from fraud. This completely destroys the Department of Justice's case against Georgia, Texas, and Florida, all three having passed new election reform laws. There's no way they're getting these things through court now, given the Supreme Court decision today. And that's not the only big Supreme Court decision today. The other decision is arguably even bigger. And we'll get to that when we come back.
I really do like his opinion.
1 minute promo.